The lawyers stopped the signing meeting halfway through the documents. One of them asked a quiet question about the ownership of a patent connected to the system behind $950 million acquisition. Until that moment, everyone in the room believed the technology belonged to my company. For a moment, it sounded routine. Then the room went still in a way that usually means something has gone wrong. That was the moment people began looking at me differently. 2 weeks earlier, none of them expected me to be there at all. My name is Kestrel Whitaker. I am 38 years old. At the time, I believed my involvement with the deal had already ended. The company had removed me from the acquisition project during a short meeting with our chief executive officer, Miranda Caldwell. I was asked to come to her office late on a Monday morning. The explanation she gave was direct and carefully worded. She said the company needed a different leadership structure for the final phase of the acquisition. She added that the investors expected executive leadership in the room, not engineering staff. The deal involved the purchase of our platform for $950 million, and she believed the transition required someone else in charge. I asked whether the decision had anything to do with the architecture I had spent years building. Miranda leaned back slightly and answered without hesitation, "This is my power. You will have to accept it." She slid a severance envelope across the table. I left her office carrying the envelope and walked past the conference room where my team was still preparing the presentation for the final signing. No one looked up when I passed the door. At the time, I assumed the company would finish the deal without me. I did not yet realize that the system behind that acquisition had a history the company had never fully examined. The system at the center of that acquisition did not begin as a company project. It started late at night while I was trying to fix a problem no one else seemed interested in solving. Our platform kept failing whenever traffic surged across regions. Engineers spent more time patching the system than improving it. One evening, I told my manager, Daniel Rourke, that the routing logic was the real issue. He shrugged and said, "Then fix the routing." "I can try," I said, "but the current system can't adapt fast enough." Daniel looked at me for a moment and replied, "If you think you can build something better, build it." So I did. For several weeks, I worked on a new traffic distribution framework on my own repository, and it was simpler and more adaptive than the existing system. Eventually, I demonstrated it during an internal review. Our chief technology officer watched the test run quietly. After the presentation, he said, "This changes the scale of what we can sell." Within a few months, the company integrated the framework into the main platform. Later that year, our CEO presented the system to investors during a strategy meeting. "This architecture," Miranda Caldwell told them, "positions our platform for long-term expansion." She did not mention my name. I remember sitting at the back of the room listening to the presentation and telling myself that credit was less important than stability. The system worked. That seemed like enough. Over time, it became the strongest feature in the platform. It also became the reason another company offered to buy ours for $950 million. At the time, I believed the architecture belonged to the company. Looking back now, I realize that assumption shaped everything that happened next. 2 days after I left the company, a certified envelope arrived at my apartment. The return address belonged to a law firm in Boston. I almost ignored it. Most official letters that show up after a termination are about paperwork. Inside was a single page asking about licensing rights connected to a patent related to adaptive load distribution in hybrid cloud environments. The number printed beside the patent looked familiar, but I couldn't immediately place it. I called the number listed at the bottom of the page. A woman answered, "Hollander and Pike? Intellectual Property Division?" I received a letter about a patent. I said, "I think there's been a mistake. What's your name, Kestrel Whitaker?" There was a brief pause. Then she said, "No mistake, Ms. Whitaker. Our client asked us to contact the registered inventor. I'm not a patent holder." I replied, "The company owns our infrastructure technology. Our records show the patent was filed under your name." "That doesn't sound right. You might want to confirm through the United States Patent Database," she said calmly. "The filing date is 5 years ago." After the call ended, I opened my laptop and searched the number. The page loaded slowly. When the document appeared on the screen, I felt a strange stillness settle in. Inventor Kestrel A. Whitaker? No company listed as owner. At the time I filed it, the architecture was still a prototype that existed outside the company's official platform. The system was integrated later, long after the original filing. I called the law firm back. I see the record. I said, then you understand why we contacted you. I filed that during an early prototype stage. I told her the system wasn't even part of the company platform yet, which is exactly why the ownership matters, she replied. You're saying the company doesn't own the patent. I'm saying the legal record shows you do. I sat back from the laptop and read the document again. 5 years earlier, I had uploaded technical documentation for the architecture when it still existed as a small independent experiment. At the time, it seemed like routine paperwork. Now that forgotten filing had reappeared at the center of a $950 million acquisition. After reading the patent record 3 times, I called the one person who might remember how that filing happened. Hollis Mercer answered on the second ring. Kestrel, he said. You sound like something just broke. Maybe it did. I replied, do you remember the load distribution prototype I built years ago? The one that kept your servers from melting down every Monday morning? That one. I remember. I just found a patent connected to it. I said, filed under my name. Hollis was quiet for a moment. Then he said, good. That means it worked. You told me to file it. I reminded him, but I don't remember why. Because I've watched companies do the same thing for 30 years. He said, an engineer solves the problem. The company calls it strategy. I assumed the company owned it once we integrated the system. Did you build the first version on your own repository? Yes. And did the company ask you to file the patent after integration? No. Then it's yours. It can't be that simple. It usually is. Hollis replied. Ownership depends on when the invention existed, not when executives started talking about it. I leaned back in my chair. The architecture is the core of the acquisition deal. I said, I figured it might be someday. He answered, you knew I suspected. You never told me. You wouldn't have believed me then. He said, engineers rarely do. If the patent belongs to me, I said slowly, then the company can't transfer the technology. That's correct. And the acquisition can't close without it. That's also correct. I sat quietly for a moment, letting the logic settle into place. 5 years earlier, Hollis had insisted I upload the patent documentation before I left for a conference. I barely remembered signing the final forms. You once told me something I didn't understand. Like I said, what was that you said? Systems don't disappear. People do. Hollis gave a short laugh. And now you're seeing what I meant. Do you think companies should automatically own inventions? Employees create outside official projects. The first call came the morning after I spoke with Hollis. It was someone from Human Resources. Kestrel. We're reviewing a few documents related to older infrastructure projects, she said. There may be a filing error connected to a patent. What kind of error? I asked. A technical one. She replied quickly. Nothing serious. You're referring to the load distribution patent. There was a pause. Yes, she said. That one. According to the patent office, and I'm the inventor. Yes, that's correct, she said. But we believe the ownership should belong to the company. Should belong, I repeated. We'd like to discuss a simple correction agreement. I'll think about it. I said. 2 hours later, the phone rang again. This time, it was Daniel Rourke, our chief technology officer. Kestrel, he began, sounding unusually careful. This patent situation is creating confusion. What kind of confusion? The acquisition lawyers flagged it during due diligence. So they noticed. Daniel cleared his throat. You understand the architecture was developed while you worked here. You also know the first version existed before the company integrated it. That may be technically true, he said, but we'd like to resolve the ownership cleanly. How clean? Compensation, he replied, and recognition. Later that evening, Miranda Caldwell called. Her voice was calm, almost reassuring. Kestrel, we both know the acquisition is important for everyone involved. I'm aware of that. The patent filing created a misunderstanding. She continued, but we can solve it quickly. How we offer you a consulting title connected to the transaction announcement, she said. along with $200,000 and a public statement crediting your contribution. For a moment, I wondered how much the acquisition bonus was worth to her. And the patent. You sign a transfer agreement? I waited a moment before answering. That system is the core of the deal. Miranda didn't deny it. You'll still benefit, she said, but the company needs full ownership. In that moment, I finally understood something. The reason she removed me from the project 2 weeks earlier wasn't about restructuring. It was about control. The next morning, I called a patent attorney recommended by Hollis. Her name was Danica Rourke. Her office was downtown, not far from the waterfront. When I arrived, she didn't waste time with introductions. Let's start with the patent number. She said I gave it to her. She read through the filing record on her screen while I explained the situation with the company and the acquisition. After several minutes, she leaned back in her chair. So the company fired you, she said. Yes. And now they want the patent transferred before the acquisition closes. That's what they're asking. Danica folded her hands. Good. I frowned. Good, it means the patent matters. I assumed it did. She turned the screen toward me. The filing is valid, she said. You're listed as the sole inventor. The company claims the architecture belongs to them. Claims don't override filing records. She replied calmly. Could they challenge it? They can try, she said. But the timeline favors you. She pointed at the filing date. This was submitted before the code entered their official platform. That's right. And the documentation references your personal development repository. Yes, then the ownership is yours. I sat quietly for a moment. What does that mean for the acquisition? Danica didn't hesitate. It means the acquiring company can't legally use the system without your permission. And Stratus Systems. They can't sell something they don't control. For the first time since the meeting with Miranda, I felt the situation shift slightly. They're offering money. I said, how much? $200,000? Danica gave a small nod. That tells us something. What, they're worried? I looked at her. If the company needs the patent to finish the acquisition, then the buyer probably needs it even more. Danica looked at me for a moment, then nodded. We stopped negotiating with them, she said. With the company? Yes. Then who do we talk to? Danica closed the patent file. The buyer. She stood up and handed me a printed copy of the filing record. Right now, she said, you're the one person in this entire deal who actually controls the technology. I left her office thinking about that sentence for the first time since I lost my job. The situation no longer felt one-sided. The final signing meeting took place in a conference room high above downtown Seattle. The windows faced the water, and the table was already filled with attorneys, investors, and executives from both companies. When Danica and I stepped inside, the conversation slowed. One of the investors glanced at me and asked quietly, is this part of the technical review team? Danica answered before I could. She's here regarding the patent discussion. The room settled into an uneasy silence. A few minutes later, Miranda Caldwell walked in. She greeted the acquiring company's representatives with the same confident tone I remembered from every strategy meeting. Thank you all for being here, she said. We're ready to finalize the transaction. Then she noticed me. For a moment, her expression didn't change. Then she turned toward Danica. I wasn't aware Miss Whitaker would be attending. Her tone was calm, but I could hear the edge behind it. Danica replied calmly. Her presence became necessary. Miranda looked back at me. We already discussed the patent matter, she said. I assumed it was being handled privately. It is being handled, Danica said. Then I don't see why she needs to be here. One of the acquiring company's attorneys spoke up. We asked for confirmation regarding the intellectual property ownership. Miranda answered quickly. The company owns the platform. Danica opened a folder and placed a document on the table. That point is exactly what we're here to clarify. The attorney picked up the document and scanned the first page. I watched his expression change slightly. He looked at Miranda. This patent lists Ms. Whitaker as the inventor and owner. Miranda crossed her arms. That filing doesn't reflect the company's development process. The attorney looked back at the document. Ownership records tend to matter more than internal assumptions. The room grew very quiet. I realized then that this meeting was no longer about finishing the deal. It was about whether the deal could happen at all. The attorney from the acquiring company placed the patent record in the center of the table. "We need to confirm ownership before proceeding," he said. Miranda answered immediately. "The platform belongs to Stratus Systems." The attorney didn't argue. He simply pointed to the document. "This record lists Ms. Whitaker as the inventor and legal owner." Miranda leaned forward. "That filing predates the platform integration. It doesn't represent the company's work." Danica spoke before the discussion could drift. "The filing predates the company's claim. That's exactly why it matters." One of the investors looked between the two of them. "Are you saying the company doesn't control the core architecture?" Danica replied calmly. "The patent holder does." Miranda turned toward me. "You built that system while working for this company. I built the first version before the company integrated it." I said, "That's a technical detail. It's a legal one." The attorney from the acquiring firm cleared his throat. "Our due diligence confirms the patent timeline." Miranda's voice sharpened. "This acquisition involves the entire platform." "Yes," the attorney said. "And the platform relies on the patented system." She shook her head. "This is being exaggerated." Danica slid another document across the table. "This is a licensing agreement." The attorney picked it up. "Between Ms. Whitaker and our client," Danica said. Miranda stared at the paper. "This is absurd," she said sharply. "That filing has no relevance to this transaction." No one at the table agreed with her. "You negotiated with them directly," Danica answered evenly. "That's correct." Miranda's calm tone finally disappeared. "You had no authority to interfere with this transaction." Danica didn't react. "The patent holder has full authority." One of the board members leaned toward Miranda. "Why wasn't this discovered during our internal review?" he asked. "Did we know about this filing?" Miranda didn't answer immediately. "This discussion should happen privately," she said. The attorney shook his head. "It can't without a license. The technology cannot transfer." The silence in the room grew heavier. I watched Miranda look from one document to another, realizing the structure of the deal had changed. The company could still sell its assets, but it couldn't sell the system that made the company valuable. And for the first time since that meeting in her office, Miranda no longer controlled the outcome. The meeting ended without the signatures anyone expected that morning. Within a few hours, the company's board scheduled an emergency review. I wasn't invited to those discussions, but people talk more than they realize in situations like that. 2 days later, Daniel Rourke called me. "You've probably heard about the investigation." He said, "I've heard something started. The board is reviewing internal emails related to the acquisition." Several board members had attended the signing meeting themselves. "Why now?" "Because the patent changed the structure of the deal," he said. "They're asking how that happened." I waited. Daniel sighed quietly. "They found messages from Miranda." "What kind of messages?" "Instructions to remove you from the project before final negotiations." "That doesn't surprise me." "There's more," he said. "The compensation structure for the acquisition included a large executive performance award." "How large?" "Several $1 million tied to the closing of the transaction, and she wanted full credit." That appears to be the conclusion the board reached. 3 days later, the news appeared on several technology sites based in Seattle. Miranda Caldwell had resigned as chief executive officer. The company released a short public statement. Leadership restructuring following internal review. No mention of the patent, no mention of the meeting, just a single paragraph announcing the change. Later that evening, Daniel called again. "The board wants to continue discussions about the acquisition," he said. "With me?" "Yes." After the call ended, I read the company's statement one more time. It was strangely quiet for the end of something that had once seemed so certain. The acquisition eventually moved forward, just not the way anyone expected. A week after Miranda resigned, the acquiring company's legal team invited Danica and me to another meeting. This one was smaller and far less tense. One of their directors spoke first. "We'd like to license the patent directly from you," he said. "The platform still depends on it." "For how long?" I asked. "For the life of the agreement," he replied. "And we'd also like you involved in protecting the rest of the infrastructure." Danica glanced at me but didn't say anything. I nodded. "Then we should talk about terms." A few months later, I was working with their engineering group, helping them build a framework for protecting intellectual property inside large projects. It wasn't the job I had expected to have that year, but it made sense. One afternoon, a younger engineer asked me something during a review meeting. How do you stop people from taking your work? I thought about that for a moment. You document it. I said, and you don't assume someone else will protect it for you. He nodded slowly. For the first time in my career, I wasn't sitting at the back of the room while someone else presented the system. Looking back, the hardest part of the whole situation wasn't losing my job. It was realizing how easily people assume their work belongs to someone else. If there's one thing I'd say to anyone building something important, it's this: make sure your work has a record that can't disappear. And if you've ever faced a situation where your work was taken or ignored, I'd be interested to hear how you handled it.